If you've decided to file a trademark application, the next big thing to decide is who should be listed on the application as the owner. Not listing the appropriate owner from the outset can create legal headaches that can only be fixed by creating a paper trail and paying unnecessary fees. So getting this right from the start can save you time and money. Hey friends, welcome back to my YouTube channel. I'm Faith Minton, an attorney on a mission to simplify trademark law for entrepreneurs and business owners. Here you will find tons of easy to understand content to help you better navigate the crazy world of trademarks and learn how to stay on the right side of the law. And today's topic is the oh so important one about trademark ownership. Because when you apply to register your trademark to get nationwide protection over your brand identity, that includes names, taglines, and logos, and even more, the United States Patent and Trademark Office will want to know on whose behalf the application is being submitted. And while the form of the trademark application does give you a bunch of different options to choose from, you do not want to just mindlessly choose the first one that looks correct. Because like I said at the outset, choosing incorrectly can create legal headaches that can only be fixed with a bunch of effort and time and money. Plus, your decision about who the trademark applicant will be can have long-reaching effects on your business, so you want to make this decision carefully. On the USPTO form, there are a bunch of different options that are listed regarding the trademark applicant. Too many for me to go through each of them here and list pros and cons for each. And that would just get really boring, quite honestly, both for you and me. And what did I say at the beginning of this video? My goal is to simplify trademark law, not to complicate it. So in the simplest of choices, if you are a business owner, choosing who will own your trademark application boils down to whether you will own it in your own name or whether you will not own it in your own name. With just those two options, it's a lot easier for us to examine pros and cons. So let's do that now. If you are choosing to own the trademark in your own name, that could mean that you are applying as an individual or even a group of individuals if there are multiple people involved in the business and who will want to own the trademark. In terms of pros, applying as an individual is super simple because you don't have to make any other additional filings on top of the trademark filing. Because as an individual, you already have paperwork behind your name, whether that's a passport or a driver's license or whatever. There is already a legal record establishing your legal identity as a person. You won't have to submit this stuff as part of your trademark application, right? The point I'm making is that if you decide to apply for the trademark not in your own name, that means you're going to set up some type of legal entity, and that does require filing some paperwork to establish the identity of the business. As an individual, that paperwork already exists for you. And because of that, filing a trademark as an individual might be a bit more cost effective because making legal filings means paying legal fees. And those can add up depending on what kind of business structure you're trying to set up. That being said, the cons of applying for a trademark as an individual or a group of individuals are pretty significant. First, any trademark disputes could and likely will involve your personal assets because there is no legal separation between the trademark on the one hand and you as an individual on the other hand. You also have to consider that there are certain tax advantages that are available to corporations and LLCs, which are not available to individuals. So any income generated from a trademark that you own in your own name, such as revenue from licensing, may be taxed at a higher rate than if you did not own the trademark in your own name. As your business expands and grows, you'll have to think about whether owning the trademark in your personal name rubs investors the wrong way because they are used to dealing with business entities and not individuals. They have more comfort around that. So related to that is the idea that not having your trademark owned by an entity makes you look less than professional in certain circumstances, depending on your industry, and that can have negative consequences for different types of deals you're trying to do. Then you had to think about complicated things like what happens to the trademark when you pass away or if you lose the ability to make decisions for yourself because of a health issue. or because you have to file personal bankruptcy. Who will have power over the trademark since you are listed as the owner? It creates a massive legal headache, but even more so if a group of individuals owns the trademark, which means that they all collectively and individually own the trademark in their own names. If one of your partners dies or becomes incapacitated or files personal bankruptcy, or if the partnership just happens to go sour and you want to part ways, what happens to the trademark then? The answer, in most cases, quite honestly, is going to be some nasty, horrible court case that takes years and years to resolve. Or if you happen to settle the dispute out of court, it's just not going to be pleasant because you're negotiating under the gun, with your trademark essentially being held hostage as part of that negotiation. So for all these reasons and even more that I haven't covered here, savvy business owners choose not to own their trademarks in their own name. Instead, they choose to have business entities like corporations or LLCs to own the trademarks for the business. Certain business owners with very complex tax, privacy, and estate planning needs may even choose to have a trust own their trademark. But trust creation is a monster of a topic that goes way beyond what this channel is for. The point is that having a trust own the trademark is an option for those who desire that. Now, in terms of the pros of applying for a trademark not in your own name, it's a reverse of all the cons, right? With an entity like a corporation or an LLC owning the trademark, you don't have to worry too much about trademark disputes spilling over into your own personal finances, because with a corporation or an LLC, you should have the benefit of limited liability. Limited liability is the legal concept that the debts, financial obligations, and other liabilities of a business do not stretch to its owners. It is one of the main reasons why people form corporations and LLCs in the first place, because they want to protect their personal assets from any business disputes. Another reason why people choose to set up corporations and LLCs is because of the tax benefits that you can get, like I mentioned earlier, which are available in those kinds of entities which are not available to individuals. Even more, setting up a legal entity kind of makes you look a bit more professional, like you have things together as a business owner, which can bode really well for certain types of transactions. If you're attracting partners or investors or certain kinds of deals, people feel more comfortable working with you if they know that you have set up the right legal foundation for your business by establishing a corporation or an LLC. If you have partners in the entity structure, you will want to make sure that the governing documents for your entity clarify that the trademark is owned by the entity so that no partner can take it when they leave. And it should also clarify what happens to the trademark if the partnership dissolves and liquidates, so that you don't otherwise end up in court over these things, which is what can happen if you don't have a clear agreement. And my favorite pro of all time for having an entity own a trademark is that the trademark is an asset. It can and should go on your balance sheet and contribute to the overall net worth of your business. If or when you sell your business, the purchase price will need to account for the value of that trademark. And for those businesses that are doing really well and whose trademarks have really high value, you may even be able to collateralize the trademark, which means that you can borrow against the value of the trademark almost the same way that you can borrow against the value of real estate. So when you consider the pros, the cons aren't all that bad. Yeah, you do need to pay some legal fees to make a filing to set up a corporation or an LLC, and you do have to keep up with the requirements to keep that corporation or LLC active in your state. But so what? The benefits far outweigh the downsides. And if you're going to be a true business owner, you are going to have to set up a corporation or LLC anyway, because people won't take you seriously otherwise. So it's not like deciding to have the entity own a trademark instead of owning it in your own name is going to add something new and difficult to your plate. And that's a wrap. Now you know that owning a trademark in your own name can be simple at the outset, but it comes with significant downsides that you will want to avoid for many practical reasons, such as protecting your personal assets, making yourself look more credible and attractive to investors and partners, being able to claim the ownership of your trademark on your business balance sheet, It just makes sense to have an entity like a corporation or an LLC to own the trademark for you. If you enjoyed this video, I hope you will give it a thumbs up. Please be sure to subscribe for more trademark content and to turn on notifications so you never miss when I post a new video. If you have thoughts or questions to share, I invite you to put them in the comments. I read and respond personally to each one, and I would love to hear from you. Thank you for watching as always, and stay tuned for the next video.